opposition team in this debate suggested that we should adjudicate the guilt or innocence of somebody on the basis of facts and evidence. We wholeheartedly agree. We think that the court of law and the law in general should adjudicate facts and evidence, not ill-founded suspicions in the total absence of information, which is what that team guarantees you in this debate. Because if you were to believe Natalie's speech, we live in a police state where the state has an incentive to try and fabricate evidence or trap innocent people and find them guilty. She never wanted to engage with the reality, which is that the state has no interest in doing that. There's no interest in locking up individuals who are not guilty of crimes. And a court of law has a significant number of protections to avoid that. The way you ensure that only guilty people are locked up and that innocent people go free is you find out information which would suggest their guilt or innocence, and you allow a court of law to adjudicate that information. So the first question I want to ask to really clarify what's happening in this debate, and you can calm down with the flailing, is what is the intent of somebody when they withhold information by pleading the fifth? Because to be clear, you plead the fifth because to give information would incriminate yourself in a legal sense. It would suggest that you have committed a crime, or there would at least be a case to be made against you by the state for committing a crime. So that is what they allow. People to avoid giving information where they may actually be capable of being prosecuted and being put in jail. People don't avoid giving this information for just generic reasons of wanting to remain private. They have an interest. That interest is to avoid justice where the person has been complicit in the commission of a crime. Let's give an example to try and really clarify this debate. Because to be clear, there is a difference between Miranda rights, where we say you should not be pressured into saying anything by a police officer until you have had legal counsel, and the Fifth Amendment, where in a court of law you can refuse to answer questions that are offered to you by the prosecution on the basis that it would incriminate you, right? It is not simply people who are, no thank you, defendants in that court, but it is also witnesses. Let's talk about that. If you are brought in on subpoena as a witness to a crime, and the prosecutor says, were you at X place at X time, and what did you see? What you can do when the Fifth Amendment exists is say, I cannot answer that question because I may incriminate myself by virtue of acknowledging that I was in that person's drug den and I was there buying drugs from that person, so to give you that information would incriminate me. The necessary outcome of allowing you to withhold that information is that you do not now have a witness to the crime that the person committed that you are actually trying to prosecute. In that case, that's what they sacrifice. So not only do they lose us the capacity to prosecute the person who is witnessing that event for whatever crime they may have committed in this instance, but also the person who we're in the midst of prosecuting, because we now no longer can actually garner evidence against that person. Let's engage with some other circumstances, no thank you, of where this would play out. Because what happens when witnesses are able to plead the fifth and not answer the questions of prosecutions is that prosecutors have an incentive to create connections between you as a witness and the crime that was committed and the guilt that may perhaps be ascribed to you. They actually make things worse for those witnesses in that circumstance. Under our policy, the information will come out. There's no incentive to construct a narrative that might suggest that you as a witness were actually guilty of committing that crime in the first place and complicate the legal process. We totally avoid that problem in this debate. But to be clear, we do not sacrifice the rights of individuals to a reasonable defense of themselves. They can still defend themselves in a court of law. We find out information that they have to give us because they now cannot refuse to answer a question. We use that information in a court. That person also has a lawyer. That person can bring other evidence and other facts. We provided, no thank you, this is unclear. We provided a whole bunch of analogies in this debate that they never wanted to engage in. Why is it that somebody cannot lie, but they can simply refuse to answer a question? Why is it that somebody cannot fabricate evidence that would get them off, but they don't need to reveal information that would necessarily lock them up? And the reality is this is totally inconsistent with other legal principles. And let's look, for example, at what a prosecution can do. It can subpoena all of your financial records, all of your private information, every single business record or like statistic or anything you have in your possession, right? So the idea that the law should preference somebody's right to privacy in the instance where they are suspected of committing a crime is absolutely ridiculous. What Natalie wanted to do in this debate was pick the most convenient example, which is that somebody might choose not to answer a question, no thank you, because they were gay. They didn't want to admit to being gay, and that might somehow be bad. We recognise that might be unideal, but they never wanted to engage with what the trade-off is. If that person choosing not to reveal their sexuality means that somebody who murdered somebody gets off because we now cannot have a witness to that crime that would land that person in jail. We are happy to suggest that your right to privacy should absolutely always be secondary. Both A, when you are directly in consideration for having committed a crime, we already don't respect your right to privacy. But even to the extent that you are a witness to a crime, your right to privacy should and is always second under the status quo. We think the Fifth Amendment is an aberration of the law and something that should be rectified. Sure, on you.
So, Meg is right. You're saying that even witnesses to a crime who haven't done any crime of their own don't have the right to plead the Fifth.
Yes, because unlike you, we don't think the justice system decides that it is better to let a whole bunch of guilty people, murderers, drug addicts, rapists, roam the street to protect the privacy of individuals. We wholeheartedly disagree that that is what is done now, or that that is what ought to be done. We think that society is far better off when individuals who have committed a crime, or who are suspected of committing a crime, or who are a material witness to committing a crime, are brought to justice. And let's be clear, under the status quo, you can subpoena a witness against their will and force them to give testimony. So you've already acknowledged that people, by virtue of witnessing a crime, do not have rights to opt out of the criminal justice system. And let's engage with why. Because every single person in society has a responsibility to the protection of society. I think that responsibility is far and above more important than the right they might have to privacy, which we think is already, to some extent, sidelined by legal process in this instance and in many other instances. Most of what you heard in Natalie's speech was scare tactics about what would happen when you have an omnipotent state and a poor little person who cannot defend themselves. That is an argument for getting someone a lawyer. That is an argument for all of the protections that the justice system already has to ensure that the defense is capable of mounting